Today we're continuing to read On Liberty by John Stuart Mill. A further question is whether the state, while it permits, should nevertheless indirectly discourage conduct which it deems contrary to the best interests of the agent. Whether, for example, it should take measures to render the means of drunkenness more costly, or add to the difficulty of procuring them by limiting the number of the places of sale. On this, as on most other practical questions, many distinctions require to be made. To tax stimulants for the sole purpose of making them more difficult to be obtained is a measure differing only in degree from their entire prohibition, and would be justifiable only if that were justifiable. Every increase of cost is a prohibition to those whose means do not come up to the augmented price, and to those who do, it is a penalty laid on them for gratifying a particular taste. Their choice of pleasures and their mode of expending their income, after satisfying their legal and moral obligations to the state and to individuals, are their own concern, and must rest with their own judgment. These considerations may seem at first sight to condemn the selection of stimulants as special subjects of taxation for purposes of revenue. But it must be remembered that taxation for fiscal purposes is absolutely inevitable, and that in most countries it is necessary that a considerable part of that taxation should be indirect, that the state, therefore, cannot help imposing penalties, which to some persons may be prohibitory, on the use of some articles of consumption. It is hence the duty of the state to consider, in the imposition of taxes, what commodities the consumers can best spare, and a fortiori to select in preference those of which it deems the use beyond the very moderate quantity to be positively injurious. Taxation, therefore, of stimulants, up to the point which produces the largest amount of revenue, supposing that the state needs all the revenue which it yields, is not only admissible, but to be approved of. The question of making the sale of these commodities a more or less exclusive privilege must be answered differently, according to the purposes to which the restriction is intended to be subservient. All places of public resort require the restraint of a police, and places of this kind peculiarly, because offenses against society are especially apt to originate there. It is therefore fit to confine the power of selling these commodities, at least for consumption on the spot, to persons of known or vouched for respectability of conduct, to make such regulations respecting hours of opening and closing as may be requisite for public surveillance, and to withdraw the license if breaches of the peace repeatedly take place through the connivance or incapacity of the keeper of the house, or if it becomes a rendezvous for concocting and preparing offenses against the law. Any further restriction I do not conceive to be, in principle, justifiable. The limitation in number, for instance, of beer and spirit houses, for the express purpose of rendering them more difficult of access and diminishing the occasions of temptation, not only exposes all to an inconvenience because there are some by whom the facility would be abused, but is suited only to a state of society in which the laboring classes are avowedly treated as children or savages and placed under an education of restraint to fit them for future admission to the privileges of freedom. This is not the principle on which the laboring classes are professedly governed in any free country, and no person who sets due value on freedom will give his adhesion to their being so governed, unless after all efforts have been exhausted to educate them for freedom and govern them as freemen, and it has been definitively proved that they can only be governed as children. That their statement of the alternative shows the absurdity of supposing that such efforts have been made in any case which needs to be considered here. It is only because the institutions of this country are a mass of inconsistencies that things find admittance into our practice which belong to the system of despotic, or what is called paternal, government, while the general freedom of our institutions precludes the exercise of the amount of control necessary to render the restraint of any real efficacy as a moral education. It was pointed out in an early part of this essay that the liberty of the individual in things wherein the individual is alone concerned implies a corresponding liberty in any number of individuals to regulate by mutual agreement such things as regard them jointly and regard no persons but themselves. This question presents no difficulty so long as the will of all the persons implicated remains unaltered. But since that will may change, it is often necessary, even in things in which they alone are concerned, that they should enter into engagements with one another, and when they do, it is fit, as a general rule, that those engagements should be kept. Yet in the laws, probably, of every country, this general rule has some exceptions. Not only persons are not held to engagements which violate the rights of third parties, but it is sometimes considered a sufficient reason for releasing them from an engagement that is injurious to themselves. In this and most other civilized countries, for example, an engagement by which a person should sell himself or allow himself to be sold as a slave would be null and void, neither enforced by law nor by opinion. The ground for thus limiting his power of voluntarily disposing of his own lot in life is apparent, and is very clearly seen in this extreme case. The reason for not interfering, unless for the sake of others, with a person's voluntary acts is consideration for his liberty. His voluntary choice is evidence that what he so chooses is desirable, or at the least endurable to him, and is good, is on the whole best provided for by allowing him to take his own means of pursuing it. But by selling himself for a slave, he abdicates his liberty. He forgoes any future use of it beyond that single act. He therefore defeats, in his own case, the very purpose which is the justification of allowing him to dispose of himself. He is no longer free, but is thenceforth in a position which has no longer the presumption in its favor that would be afforded by his voluntarily remaining in it. The principle of freedom cannot require that he should be free not to be free. It is not freedom to be allowed to alienate his freedom. These reasons, the force of which is so conspicuous in this peculiar case, are evidently of far wider application. Yet a limit is everywhere set to them by the necessities of life, which continually require, not indeed that we should resign our freedom, but that we should consent to this and the other limitation of it. The principle, however, which demands uncontrolled freedom of action in all that concerns only the agents themselves, requires that those who have become bound to one another in things which concern no third party should be able to release one another from the engagement, and even without such voluntary release, there are perhaps no contracts or engagements, except those that relate to money or money's worth, of which one can venture to say that there ought to be no liberty whatever of retractation. Baron Wilhelm von Humboldt, in the excellent essay from which I have already quoted, states it as his conviction that engagements which involve personal relations or services should never be legally binding beyond the limited duration of time, and that the most important of these engagements, marriage, having the peculiarity that its objects are frustrated unless the feelings of both the parties are in harmony with it, should require nothing more than the declared will of either party to dissolve it. This subject is too important and too complicated to be discussed in a parenthesis, and I touch on it only so far as is necessary for purposes of illustration. If the conciseness and generality of Baron Humboldt's dissertation had not obliged him in this instance to content himself with enunciating his conclusion without discussing the premises, he would doubtless have recognized that the question cannot be decided on grounds so simple as those to which he confines himself. When a person, either by express promise or by conduct, has encouraged another to rely upon his continuing to act in a certain way, to build expectations and calculations, and stake any part of his plan of life upon that supposition, a new series of moral obligations arises on his part towards that person, which may possibly be overruled, but cannot be ignored. And again, if the relation between two contracting parties has been followed by consequences to others, if it has placed third parties in any peculiar position, or, as in the case of marriage, has even called third parties into existence, obligations arise on the part of both the contracting parties towards those third persons, the fulfillment of which, or at all events, the mode of fulfillment, must be greatly affected by the continuance or disruption of the relation between the original parties to the contract. It does not follow, nor can I admit, that these obligations extend to requiring the fulfillment of the contract at all costs to the happiness of the reluctant party, but they are a necessary element in the question. And even if, as von Humboldt maintains, they ought to make no difference in the legal freedom of the parties to release themselves from the engagement, and I also hold that they ought not to make much difference, they necessarily make a great difference in the moral freedom. A person is bound to take all these circumstances into account before resolving on a step which may affect such important interests of others. And if he does not allow proper weight to those interests, he is morally responsible for the wrong. I have made these obvious remarks for the better illustration of the general principle of liberty, and not because they are at all needed on the particular question, which, on the contrary, is usually discussed as if the interest of children was everything, and that of grown persons nothing. I have already observed that, owing to the absence of any recognized general principles, liberty is often granted where it should be withheld, as well as withheld where it should be granted. And one of the cases in which, in the modern European world, the sentiment of liberty is the strongest is a case where, in my view, it is altogether misplaced. A person should be free to do as he likes in his own concerns, but he ought not to be free to do as he likes in acting for another, under the pretext that the affairs of another are his own affairs. The state, while it respects the liberty of each in what especially regards himself, is bound to maintain a vigilant control over his exercise of any power which it allows him to possess over others. This obligation is almost entirely disregarded in the case of the family relations, a case, in its direct influence on human happiness, more important than all others taken together. The almost despotic power of husbands over wives need not be enlarged upon here, because nothing more is needed for the complete removal of the evil than that wives should have the same rights and should receive the protection of law in the same manner as all other persons. And because, on this subject, the defenders of established injustice do not avail themselves of the plea of liberty, but stand forth openly as the champions of power, it is in the case of children that misapplied notions of liberty are a real obstacle to the fulfillment by the state of its duties. One would almost think that a man's children were supposed to be literally, and not metaphorically, a part of himself, so jealous is opinion of the smallest interference of law with his absolute and exclusive control over them, more jealous than of almost any interference with his own freedom of action. So much less do the generality of mankind value liberty and power. Consider, for example, the case of education. Is it not almost a self-evident axiom that the state should require and compel the education, up to a certain standard, of every human being who is born its citizen? Yet who is there that is not afraid to recognize and assert this truth? Hardly anyone, indeed, will deny that it is one of the most sacred duties of the parents, or as law and usage now stand, the father, after summoning a human being into the world, to give to that being an education fitting him to perform his part well in life towards others and towards himself. But while this is unanimously declared to be the father's duty, scarcely anybody in this country will bear to hear of obliging him to perform it. Instead of his being required to make any exertion or sacrifice for securing education to the child, it is left to his choice to accept it or not when it is provided gratis. It still remains unrecognized that to bring a child into existence without a fair prospect of being able not only to provide food for its body, but instruction and training for its mind is a moral crime, both against the unfortunate offspring and against society, and that if the parent does not fulfill this obligation, the state ought to see it fulfilled at the charge, as far as possible, of the parent. Were the duty of enforcing universal education once admitted, there would be an end to the difficulties about what the state should teach and how it should teach, which now convert the subject into a mere battlefield for sects and parties, causing the time and labor which should have been spent in educating to be wasted in quarreling about education. If the government would make up its mind to require for every child a good education, it might save itself the trouble of providing one. It might leave to parents to obtain the education where and how they pleased, and content itself with helping to pay the school fees of the poorer class of children, and defraying the entire school expenses of those who have no one else to pay for them. The objections which are urged with reason against state education do not apply to the enforcement of education by the state, but to the state's taking upon itself to direct that education, which is a totally different thing. That the whole or any a large part of the education of the people should be in state hands, I go as far as anyone in deprecating all that has been said of the importance of individuality of character and diversity in opinions and modes of conduct involves as of the same unspeakable importance. Diversity of education. A general state education is a mere contrivance for molding people to be exactly like one another, and as the mold in which it casts them is that which pleases the predominant power in the government, whether this be a monarch, a priesthood, an aristocracy, or the majority of the existing generation, in proportion as it is efficient and successful, it establishes a despotism over the mind, leading by natural tendency to one over the body. An education established and controlled by the state should only exist, if it exists at all, as one among many competing experiments carried on for the purpose of example and stimulus to keep the others up to a certain standard of excellence. Unless, indeed, when society in general is in so backward a state that it could not or would not provide for itself any proper institutions of education, unless the government undertook the task, then indeed the government may, as the less of two great evils, take upon itself the business of schools and universities, as it may that of joint stock companies, when private enterprise, in a shape fitted for undertaking great works of industry, does not exist in the country. But in general, if the country contains a sufficient number of persons qualified to provide education under government auspices, the same persons would be able and willing to give an equally good education on the voluntary principle, under the assurance of remuneration afforded by a law rendering education compulsory, combined with state aid to those unable to defray the expense. And that's the end of the reading for today. Have a good day.